Hello and welcome to the Book Club of the Lotus Eaters. This time we're going to be looking at the Protection of Free Speech, which is a document that's been published by Lawrence Fox and the Reclaim Party, looking at the legal analysis of freedom of speech within the UK and what needs to be solved.
Yeah, this is a series of analyses about the current state of affairs and proposals for what should be done to promote the sort of classical liberal value of freedom of speech in the place that invented the classical liberal value of freedom of speech.
Which has abandoned it.
For some reason.
Primarily to Tony Blair's Labour Party.
Although,
and been upheld by the Conservative Party ever since.
Although, as we see, this has been going on for a while, even before Blair. So I guess to give us a quick overview, it's a legal analysis by barrister Francis Hoar, H-O-A-R, contributed to by Lucille Taylor and Anna Lufty, forward by Lord Sumption. You were familiar with him?
Yeah, the guy who used to be on the... I forget the court he was on.
I can't remember. But anyway, and a preface by Lawrence Fox. It was commissioned by Lawrence Fox and the Reclaim Party, and it's a philosophical and legal argument with proposals on how the government can protect free speech in Britain, split into 8 sections. The forward and preface are both well-considered rhetorical pieces to set the stage for the need for protection of free speech in both online and offline in Britain. But I expect that the people watching this will be familiar and in broad agreement with those, so we won't dwell on them, and I'll skip over the executive summary and just get straight to the meat of it. It's an interesting point
about the online and offline stuff, though. When we found out about Cantanker's conviction and the Liberalists ran the letter-writing campaign, the stock response we ended up getting from the Conservative Party whenever we wrote to any one of their MPs was that I believe that offline and online speech should be treated the same, even though it obviously wasn't, because you could do what Count Dankula did offline. It was the online part that made him a criminal.
Yep. That's interesting. Right. So in the introduction, it's a rhetorical argument for freedom of conscience, freedom of speech and freedom of assembly. It's pretty well compiled and delivered. It draws heavily on the view of personal freedom espoused by John Stuart Mill. This is a fairly secure place to start, although there are good criticisms of Mill, I have to say, especially in regards to his utilitarianism, which I'm probably going to make an against utilitarianism series of podcasts at some point. But his views on liberty are pretty concrete and fairly hard to challenge. These stem from the personal ability and responsibility of the individual, and on an individual level, they are hard to challenge. Mill, of course, did predict many of the problems we're facing now, presumably because he was facing the same problems in his own day, but coming from religious conservatives rather than leftist activists. His 4 arguments against censorship are, to summarise, to silence opinion is to assume infallibility. And of course, you're not infallible, so you shouldn't be silencing. A silenced opinion may contain a portion of the truth, and so it may have value to us. Even if our orthodoxy is the truth, it will be poorly understood if it's not challenged, which I think is a good point. And the very meaning of a doctrine is enfeebled if it's not challenged. Now, I actually take issue with the...
That first one is particularly awful.
No, I don't think so. I actually think that's good.
Well, the idea that you're fallible, therefore you shouldn't be allowed to censor anything is not a good argument in my view. Because, for and foremost, some of the things we have to address when talking about free speech and the law is that there are restrictions on what you can post online, and rightfully, we can agree, for example, that posting pro-pedophilia content, child pornography, these kind of things, you could class them as speech and they're still illegal for good reason, and I don't have to even make the argument.
Sure.
So the point that, well, you're infallible, therefore you can't censor anything, no, there are things that are to be censored.
Sure, but he's specifically speaking about opinion. And political opinion. So, I mean...
In that aspect, perhaps.
Yeah. But. So there may be material that can't be put online, which I agree with, but that doesn't mean opinion should be censored itself. And he is right to silence opinion is an assumption of infallibility. That's correct. But the thing is, the problem with this is it's all utilitarian, which means it's all external and speaking to consequences and values around you, right? This actually, I think, misses a key trick that there is an inherent moral wrong in the act of censorship because you are actively suppressing someone's human rights. And that's something that Mill doesn't hit on there. And that's the problem. One of the problems with utilitarianism is it is not engaging in the inherent wrongness or rightness of an action. And I think that it is inherently wrong to censor. And so if you have to censor, then you've got to have a bloody good reason for it. And so that's something that I think actually that Mill misses. But otherwise, it is a fairly time-tested and in their day victorious arguments. So it's not a bad framework to demonstrate one's intentions with for this report, which is fine.
It also speaks to our history and the fact that we used to be at this position, it was accepted,
Yes.
it won the argument,
Yes.
and has subsequently been rejected.
Yeah, and the key point that Mill was making on liberty is not just censorship bad, but it is that the government is not the only censor in society, and in fact a censorious society will be as, if not more, oppressive than a censorious state, because society is what you are living in. It's the water you swim in, it's all pervasive, whereas the government has limits on just practical limits as to what it can track.
Like I believe the way he said it is that it cuts more deeply and therefore enslaves the soul itself.
Yes.
Because if everyone around you is able to censor your entire society,
yes,
that's even worse than the government.
Absolutely. Anyway, so the first section that we'll look at is free speech and the law, freedom of speech and the law. So this section describes the problems of current law with respect to free speech. He begins with 3 quotes by Lords Bingham, Hoffman and Sedley, all judges who have made concrete judgments about free speech being a necessary right that should be protected. The general thrust of these is that the government should not have the right to decide what is and is not acceptable speech. Not a controversial position. It's anti-democratic, and that it is only profane speech that needs protecting. Whatever is considered heretical to the current social environment, that's the speech that needs protecting, and that's how it will always be. All good and classic positions within the English liberal tradition. So he moves on to where these things are being addressed. He starts with the European Convention on Human Rights, Article 10, which is based on common law developments. It upholds your right to hold opinions and express them freely without government interference. This means published articles, books, leaflets, television or radio broadcasting, works of art, internet and social media. It also protects your freedom to receive information from other people by being part of an audience or reading a particular thing. It's important stuff, but it contains restrictions. Quote, in the interests of national security, for the prevention of disorder or crime, for the protection of health and morals, for the protection of the reputational rights of others, for preventing the disclosure of information received in confidence, or for the maintaining the authority and impartiality of the judiciary. These seem fairly broad, but they do stress that the exceptions must be, quote, narrowly interpreted and convincingly established.
They aren't.
I'm sure they're not.
But the reason I'm shaking my head, for anyone wondering, is not because I disagree that you shouldn't have such rights, but that wording from the European Union's Convention on Human Rights, the European Convention on Human Rights, is lifted directly from the UN's version, which was redrafted by the Soviets after they got mad about the original draft that just said you had the rights. They were like, no, what about public order, health, society, security?
What about our control over society?
Yeah, and that's why you have that Section 2 of Article 10.
Yeah. And so Article 17 of the EHRC can also be used to restrict freedom of speech, they point out. Nothing in the convention may be interpreted as implying for any state, group or person any right to engage in any activity or perform any act aimed at the destruction of any rights and freedoms set forth therein, the limitation to a greater extent than is provided for in the convention. But if the speech violates the dignity of another person or minorities, protected in Article 14, which is the right of protection from discrimination, this actually creates caveats. This puts them in a bind where they have contradictions within their own document laying out what you're free to do.
Yeah, because it's written in a nonsensical way.
And it's written to appease the Soviets. If it was written purely to appease the classical liberals, there wouldn't be these contradictions and these caveats wouldn't be included.
The original draft, written by, I think, the Americans and the Anglos at the time, that the Soviets rejected in the UN, was just, you have these rights, same way you would write the US Constitution. Not unless we say so.
Yes.
The Soviets added the part where it's unless we say so.
Yes, because the Soviets are like, we don't agree with rights. Anyway, Dr. Preston Byrne argued that Article 10.1 is, quote, woefully inadequate, weakly implemented rule of law, which has, in the form of Article 10.2, more often than not actually been used to restrict freedom of speech than expand it. It allows the boundaries of legal speech to drift in line with contemporary cultural currents, which is actually not good, instead of being anchored in some objective permanent principle, which would, again, be the classically liberal position of you have free speech because you are free to speak. But anyway, they move on and lay out the state of the laws that deal with speech in the Criminal Law Code. So at the moment, there seem to be Section 1 of the Malicious Communications Act 1988, Section 127 of the Communications Act 2003, various sections of the Public Order Act 1986, and of course the latest Hate Crime and Public Order Bill for Scotland. These are the 4 things that really dominate English or British law.
Yes. The most used by the police and abused by the police.
Each of these has various provisions to censor and are, in the review of the author of the report, damaging free speech. The problem, of course, is that they use broad terminology, as they always do, which means they encapsulate a wide range of what is otherwise democratically acceptable speech. So they go through the main problems, which are, in the Hate Crime and Public Order Scotland Bill, this essentially acts as a blasphemy law, as the Secular Society observed, quote, "It seems to be promoting the idea that there should be a right not to be offended, and will create unreasonable expectation that religious sensibilities are protected by something akin to a blasphemy law," which we've seen in action. The Public Order Act 1986 includes the words abusive and insulting, where it should not be the state's job to police insults. If we're not free to, again, all well said, if liberty is meant to mean anything at all, it must mean the right to tell people what they don't want to hear. And an insult can definitely come under that category. If the state prevents us from insulting each other, how can I tell my neighbour I think he's a prat? Just joking, my neighbour's actually a very nice person, but, you know, the point is there. Moreover, it uses the terminology likely, as in where something is likely to stir up racial hatred. This is, of course, troublingly broad.
Has to be defined.
Yes, and it's a shell game. You know, you can say, "Oh, this was likely because of this," and you can just change around definitions. It's inappropriate to use these malleable terms in criminal law particularly, right? Because a core distinction between criminal and civil law is whether the person's intention can be established with certainty or whether it is merely likely or not. And so is it or isn't it, or is it likely or is it not likely? And so what they're doing with this law is actually importing a civil standard of proof into criminal law where it's not appropriate. So you can just be told you're likely to have been doing this, and so you're criminalised, even though they can't be certain that you've done it. So you may not have done it. Anyway. So for the Hate Crime and Public Order Scotland Bill, they don't go into excessive depth on this one because they say it's beyond the scope of the report, but they say not only does it inappropriately use the civil liability standard that we've just spoken of, juries are now asked to determine what a reasonable person thinks and how they act. That's new. That's made up. That's not got a precedent. Normally, juries are required to decide whether facts are proven or not, and on the strength of the facts, whether a particular person accused intended to cause harm or not to judge whether a reasonable person has that opinion or what they think of the situation.
Reasonable is, reasonably done this, or this is reasonable. That's massively used throughout law, but to apply that to opinions is something new and insane.
Yes, and again, like they're used to define whether the facts are the facts and whether that confirms that the person had the intention to cause harm, not whether a reasonable person would judge this likely.
Usually it's like, were your actions considered reasonable? And that's something that could be judged by a jury. Your opinions being reasonable is something that should never be judged by a jury.
Yeah. And again, this is a different standard that's been imported, blurring the lines between civil and criminal law. Also, Clause 8 of the HCPOS bill means that the state can, quote, seize material to which this offence relates. So this includes books, newspaper articles, or anything like that. Any material that they feel that you have is likely to do something that a reasonable person might think, they can just take. They also sabotage their own attempts to put restrictions on the broadness of their terminology by saying, well, nobody will be convicted solely on this behaviour, that if a reasonable person thinks could consider it to be abusive. But the thing is, they can always just make up a reason to attach to it. You can just make up whatever you like. And they have. And as the Secular Society put it, there's no need for this either. The new law is also necessary in that genuine criminal activity that the proposed offences are seeking to redress are already captured in existing law. We already have all of these things addressed and dealt with in the law that we have, so there's no need for this. So if anything, this appears to just be an extension in the scope of the state and the deliberate blurring of the lines between civil and criminal law.
Well, it's a purposeful attempt to implement blasphemy law against specific ideologies.
Yes, but it also has knock-on effects that we'll get into in a bit. The hate crime operational guidance of the College of Policing also comes under fire because this is the source of the non-crime hate incidents. So in Britain, if a police officer has it alleged at them, they can record a non-crime incident.
This can happen between citizens as well. So
Yes.
if for example, there was one that's posted recently, we haven't been able to confirm yet, but someone said that another citizen had a flag, the St. George's Cross, on their car, and therefore they were concerned they were involved with right-wing terrorism. The police officer can laugh at this, but they do have to document it as this was alleged.
Well, yeah, that's the thing. And in fact, it gets worse. So the operational guidance that they're given, which again, it was 2014, the College of Policing has the power to issue these guidances. And the guidance actually says the victim does not have to justify or provide evidence of their belief for the purposes of reporting, and officers and staff should not directly challenge this perception.
Yes.
So just accept it as read.
Regardless of how insane it is,
Yep.
regardless of how nonsensical it is.
And the reason they want to do this is because they believe that crimes are being vastly underreported, and so perception-based recording will somehow help to reduce underreporting. So if people report things that aren't crimes, somehow that helps the underreporting of crimes. Doesn't make sense. Two different categories of event.
No, I've heard
One is a
another.
crime, one is not.
I've heard another defense from a police force, which was that they use it to try and monitor the bigotry or intolerance of an area, which again is not your job.
No, absolutely
it's not a crime.
your job. But more importantly, again, you're not recording crimes, so you're not recording underreported crimes. You're recording things that are not crimes as if there's something that's been done. But that's just not the case. This is, of course, one of the reasons they bring this up is the case of Harry Miller, the Limerick criminal, who got a visit from the police to check his thinking because he liked a limerick online that is considered by the left to be transphobic. So the problems that the report points out with this are, one, the person making the complaint is definitionally not a victim because people lie.
A victim of what?
Well,
a non-crime.
Well, let's assume that somehow the hate and the non-crime hate incident could be considered worthy of it. You still don't know whether that's the case because people lie, and so you could be having someone lie to you, and you're recording a lie, and you're treating the lie as if it's true, and you're carrying on.
And it's on your permanent record.
And it's on your permanent record, exactly. A police officer has a duty to challenge a person's account. Suspicion is not reasonable if an officer accepts any allegation without evidence. That's not reasonable suspicion. That's just taking everything at face value. And of course, a free society should presume the innocence of the people being accused. Don't know why we have to say that, but that's where we are now. And recording allegations of hate has real consequences for those people accused. The record of the allegation itself can be used to discriminate against someone. It's not fair. And it's a sinister development where the state is increasing the amount of information it records about its citizens, even when there is no justification by its own standards to do it. And so it's an unacceptable and unjustified expansion of this bureaucracy of the state, which is something we should all be suspicious of.
It's also something that does affect everyone. The rich and powerful might think that they're aloof from this or something, but I think it was Amber Rudd, the Home Secretary, or whatever she was. She decided to check if she had any non-crime hate incidents against her. She had one for giving a speech at a university about immigration. It turned out the person who made the complaint never even attended.
There we go. Moving on, they speak about threats to freedom of speech online. So naturally in this, they mainly focus on Twitter, Facebook and YouTube due to their monopolistic market share. But also because each of these websites has censorship policies that are political. When it comes to vaccines, lockdowns, the Hunter Biden laptop story, the censoring of the president, various other... I mean, Twitter has actual guidelines on pronoun use and an opinion on the construction, the philosophical construction of gender and things like this. All of these are expressly political positions. Yep. What happened in the 2020 elections?
Their terms of what hate is, in which many of them rely on far-left organizations to tell them what it is, which is as worthless as anything, wouldn't stand up in court.
Yeah. And, of course, the report proposes that regulation of social media should be done to prohibit censorship rather than mandate it. But the current government's online safety bill, which is currently being debated, which is why this report was produced, actually takes the opposite approach. Now, it's not that the pro-free speech argument can't be made. Of course, countries like Poland, I think it's Hungary as well, did something like this, where any Polish citizen who is deplatformed arbitrarily by Silicon Valley will be fined by the government. Millions of dollars until their accounts are reinstated. The British government could do something very similar, frankly. They don't actually recommend that in the report, but this is just something that I've noted from the outside. Anyway, so on the section on disinformation, misinformation, fact-checking, and the illusion of safety, they reference the Online Harms White Paper, which was the precursor to the Online Safety Bill. Notice how the harms and safety has been flipped. It's not online harms, it's now online safety. So that's a different perspective. Protecting one from harm and ensuring someone's safety are two different subjects. So anyway, in this, they speak about the online harms precursor of the bill because one of the concerns about they are trying to address with this is the creation of social media echo chambers that they say are creating disinformation. And the thing is, this might be true, but the same effect can actually be created offline as well. It's actually very difficult to find a way to legislate the material that people imbibe when they're browsing or reading or whatever it is. I mean, the same effect could be achieved by a particular enthusiast in some subject going to a library and just constantly reading books on Marxism or something, and they radicalize themselves into Marxism by never hearing an alternate opinion. What are you going to do? If that happens, what are the options? And so essentially the complaint is that the Online Harms white paper presents the free exchange of information, right or wrong, as a real danger to society, quote, that, quote, encourages hostile actors from within and without to attack the body politic.
This is the exact same argument made against the printing press.
Yes, it is exactly the same argument. It also requires Ofcom to establish an advisory committee about misinformation. So the government,
which will be determined by the state.
Well, exactly. The government will be determining what truth is now, and creates a duty for websites to protect adults from, quote, harm caused by words and possibly ideas. So there are lots of problems with this. The report highlights 3 in particular ones. The government's role is not to keep people safe from all harm. It's just not that job. The government has adopted a particularly paternalistic view that has expanded its mandate for censorship and protection. They use Jonathan Haidt and Lukianoff, who Haidt wrote The Righteous Mind. I can't remember what Lukianoff did, presumably something similar, but you can find an article called The Coddling of the American Mind by Haidt, in which he essentially expands his concerns and articulates the reasons against this safetyism, and why it's bad for people, why it keeps them trapped in a state of infantile existence, and it's just really not good for them if they can't develop this kind of mental robustness. And this also contradicts the government's own initiatives to protect free speech at university. You can't hear suspicious or unusual or contradictory or offensive things online, but you are protected by the government to do those things in universities. I mean, I think you should be protected in both areas, obviously. The second point is that the government's prescribing this as a danger requires a search for a solution, when in fact, what was it? People saying things on the internet that they disagree with and may cause distress. Okay, but that's not dangerous. But if the government creates a danger here, it causes a search for a solution, meaning that the government has taken upon itself the duty to regulate information online. Misinformation in this context becomes distinctly anti-democratic language. As human rights advocacy group Article 19 say, the entire framing of the white paper is built around negative emotions of fear and a state of helplessness that demands strong government action to provide safety and protection from nebulous harms. Great point, I thought. Yeah. Point 3 is that the government has decided that it should judge what is truth and what opinions are worthy of correction or not. And of course, to this, they cite Mill saying judgment is given to men that they might use it. It also reduces the ability of people to even understand the arguments if they're not allowed to judge them for themselves. So that's a generally enervating thing. This is the very essence of Haidt's argument against this kind of safetyism. It's not good for us. Very bad for us, actually. So anyway, moving on to Ofcom and the regulation of broadcasters, the Online Harms white paper has suggested that social media and other online companies, like us in fact, should be regulated by Ofcom, and this went into the bill. This is concerning because of what is potentially inaccurate or harmful is a matter of opinion. All of this is just who's making the judgments at the time.
The managers inside the institution the government sets up.
Yeah, someone in the civil service. I don't really want those people judging what I say. So moving on to online censorship, the report argues that online censorship has taken on a regressive ethical standard that is not used in other fields. They've got a great example here, which is that of therapeutic privilege. Have you ever heard of this? Well, back in the 70s and 80s, this was something that was done quite often. Doctors would used to withhold the diagnosis of terrible diseases in order to protect the mental health of their patients.
That sounds like a really stupid idea.
Yeah. But I mean,
if we lie to them, they'll get all better.
It was only until like the 90s when babies were given anesthetic and painkillers during surgery as well. There was just a general idea that babies didn't feel pain, and so you could do open heart surgery on a baby without giving any kind of anesthetic. It's mad, isn't it? Any kind of pain relief. Anyway, there have been some really bizarre medical practices, but this is one of them. And this is obviously considered now to be unethical. It abolishes the idea of informed consent, and the same principles should apply online. Ironically, it's actually not progressive at all and incredibly paternalistic to take this approach. As with the government, it can now be expected... as with the government, how can it be reasonable to expect social media companies to establish truth? Don't know why I have to say that, but that's something that's apparently we're debating. I mean, of course, like when it comes to the current one, how can they be expected to establish whether the truth of whether vaccines are dangerous or not? Well, they don't know. No one knows yet. They seem to be fine, but like nobody knows. And with any other subject as well, any other subject. But Twitter's censored tens of thousands of tweets and challenged millions of accounts. And so we just don't know the full scope of online censorship. But as people who deal with this stuff every day, it's a lot. There are, we personally know lots of people who have been deplatformed for having opinions. So the question then becomes, well, who is a publisher online? And so in UK law, a person is only responsible for the statements they publish if they themselves publish them. So the standard that is used is the notice board standard. So this is obviously an old standard in Britain. So if someone publishes something to their own platform directly, as in if you were to put up a piece of paper in your window that had a message, that's you did that, it's your window, you're in control of that. But if someone puts a note up on a public notice board, the owner has to be given notification and reasonable time to remove the offending article. And if they don't, they're considered to endorse the message and are the publisher of it. The report says that this is actually a good legal principle, and it works, because it gives freedom to have organic content created by people, and it also gives the people who are operating the platforms for the organic content reasonable defense to take it down, or they become liable for it if they are endorsing it, which makes sense. The Online Safety Bill puts this at risk. A website, and this is mad the way that this is framed, right? A website will be liable for statements and will have a duty to enforce compliance with its own terms and conditions, but it chooses its own terms and conditions. But the way that the law is going to work is that this will be imposed on its users by statute. So a social media company could make up whatever terms and conditions, and the government will say, right, you have a legal obligation to impose those made-up social terms and conditions. So a company can't even say, we're not going to enforce this. They won't even be able to say that, right? So they won't be able to use their sort of discretion, basically. But this will also arise without complaints or claims by a user. It has to be done proactively by the platform. So now platforms can't even wait till people complain about a thing. They have to go out and police and patrol, which is a huge burden to put on, say, a social media platform or something like that.
The person who made that has no idea how these things work. Most of them are run by bots. So you're going to have the bots going out and doing this.
Absolutely. Yeah. And as Big Brother Watch point out, this is very likely to go way beyond the requirement of any domestic laws. There's nothing in domestic law that matches Twitter's view on gender. Like, there's nothing in there. They can't. And now Twitter will be required by British law to censor you, to censor someone like Harry Miller, if he has an opinion on the philosophical construction of gender. That's such a bizarre standard and a backwards way of looking at things. It's really amazing that this has got this far, to be honest.
I can't remember the lady who introduced the harms bill. I think it was a Labour MP. Is it still being endorsed as a Labour thing, or has many Conservatives signed on to it?
I would have to check. I haven't got that information. But it's just very concerning that this is what the government is currently debating. Like, we need to legally make Twitter as censorious as possible, even though that goes beyond the bounds of what the law requires Twitter censors.
I know Boris was bigging this up the other day, actually, so...
It's ridiculous.
It's nuts.
Anyway, so the purpose of this is literally to protect adults from harmful content.
Right. You can define harmful in a few ways, do they?
They do. But we'll get to that when I get to it. So... As far as the report is concerned, this represents a disturbing escalation of the power of the state. Cyber law solicitor Graham Smith observed that this is actually a bastardization of the term duty of care, because duty of care ordinarily is to avoid inflicting injury yourself. You have a duty of care not to inflict injury, not to prevent someone else inflicting injury, which is what is being offloaded onto the social media companies. So the social media user could criminally be given a liability to not inflict this injury, and so he could post something that is illegal, whatever, for whatever reason. But now this is offloading that duty onto someone else. It's not someone else's duty to prevent you from inflicting injury. It's your duty. And it also does not include the common law duty to be reasonably responsible if one creates a risk-taking activity. As Smith points out, citing the Supreme Court of Britain, actually, there is no general law prohibiting the publication of facts which will cause distress to another, even if that's that person's intention. So if you're publishing black crime statistics or something with the deliberate intention of being offensive to some activist online that will be offended by this, that's not illegal. It's the publication of facts. And where we're coming to here is the criminalization of the publication of facts. So on the section called a new statutory protection from censorship, the purpose of this is to deal with the problem of international enforcement, of course, because social media will be based outside of the UK. And so the white paper supports the idea of requiring an appointment of a representative in the UK, a nominated representative, to censor this content as desired by the UK government. So,
chief censor, if you will.
Yes, a chief censor, if you will, to tell Silicon Valley, people who aren't exactly libertarian, that they have to do things, they have a legal obligation to censor in line with their own, what was discretionary decisions. So now they don't have discretion. It's such a weird thing to have had happen. So according to the report, decisions are not made according to objective standards of criminal and civil law, but those imposed by multinational corporations, giving them the power over the public debate in this country that undermines democratic discourse and neuters freedom of speech, normally protected by the common law and ECHR. Correct. Seems to be a correct assessment. The report proposes that the host of organic material is not responsible unless it becomes a publisher. Sensible. When it becomes a publisher, it may remove information for two reasons that might reasonably appear to be in violation of criminal or civil law, or after an investigation that has come to that conclusion. Third, criminal and civil law should be amended to provide a defense for the social media company that did not remove a statement after an investigation. If a statement is removed, the user should have the right to obtain redress by compulsory arbitration. Hopefully that puts us in the line of sort of the Polish view, that you will be fined, the company will be fined. This would protect from political partisanship. Point 5 is only to sites which anyone can sign up to with no membership dues. So if, for example, if people in the comment section of lotuseaters.com were to post things, we are the publishers of those because they had to pay to be able to use our service. It's not just open to everyone. And on 6, it shouldn't apply to sites that are not hosts as the current regulations dictate. What this would all do apparently is to enable smaller sites to avoid the obligations but keep major sites under control. Quote, what this scheme would do is ensure that social media companies operate as a forum for debate and are required to do so. So we're not in a great place, but the recommendations from the report would provide a reasonable balance for the users and the platforms themselves to be able to protect themselves from what I guess we would call malicious compliance. Any thoughts?
Have there been any developments on this, or has this just been proposed?
It's just been proposed,
right.
And
Okay.
the debate is still going on about the online safety bill.
Did they end up? Were we getting into where they're defining what harm is in the online safety bill, or not yet?
I'm sure I did see it, but I may have missed it. But I'll have to look for that later.
Yeah, because that's ultimately the big crux. Because if you can define harm as, say, physical, well, okay, we're talking in terms of words here, so it would be serious psychological harm or something. That's a very high standard.
I think that is the standard that they were using.
That's much better, but there's other types in which they just define harm as you saw earlier as insulting or abusive or so on and so forth.
Yes. I think it's serious psychological harm, but I'm not sure. I'd have to check. But the point is, it's unlikely to be as rigid as I would prefer it to be. Anyway, so the final section they're concerned about is freedom of expression and employment rights, because this has been something that has affected many, many people, like literally thousands of people this has affected. I mean, the most recent example is a person who said something mean to Marcus Rashford online and got fired, and is going to be charged with some sort of criminal liability. So the report's philosophical position on this is that it's inherently wrong for a person to fear losing their livelihood for expressing their opinions online. I agree. Losing one's livelihood is, of course, the most powerful disincentive that is stifling debate, because you need that money. You need to work.
It's a public and private life distinction.
Yes, exactly. You need to be able to earn money to exist. And if things you've said online prevent you from earning money, well, that means you can't exist.
Yeah.
The 2010 Equality Act protects philosophical beliefs, but this is, of course, fraught with problems. Many, many problems. As a previous judgment has shown, the belief must be genuinely held. It must be a belief and not just an opinion on something. It must apply to a substantive aspect of human life and behavior, and must attain a certain level of cogency, seriousness, cohesion, and importance, which is all fine. I can agree that these are boundary requirements for something being called a philosophical belief and not just an opinion. I don't like salt. It's not a philosophical belief, it's just your opinion. It has to have all of these things, but the fifth one is the most concerning one. It must be, quote, worthy of respect in a democratic society and not be incompatible with the human dignity and conflict with the fundamental rights of others.
It must be politically correct.
Kind of, because the thing is, conflict with the fundamental rights of others. This puts communism as something that is not worthy of respect in a democratic society. And so hang on. So communist activism should be prescribed by the Equality Act.
That's a straightforward opinion, but that is not going to be implemented because the judge in question has to agree with you. And if the judge in question does not believe that that's the case, too bad, get stuffed. And considering that most judges and most people in authority in the UK are politically correct, that's what you're going to get if you say such standards as must be acceptable in a democratic society or whatever.
Yeah, I mean, for example, it can't be incompatible or conflict with the fundamental rights of others. What was the European Convention on Human Rights say about private property? It says you have a right to it, does it not? And so communism says we want to get rid of private property. That's in conflict with my fundamental rights.
But it also says that you have the right to free speech unless you don't.
Well, exactly, but that's the point, isn't it? That's why these things are all useless, because if they can't even get rid of the communists, what use are they? Anyway, the issue here in the report, though, is the issue of the terms respect and not tolerance. Worthy of respect. That's the problem, because this is not the same.
It's just, does the judge hate it? If the judge disagrees and hates your ideology, you're not worthy of respect.
Sure, but and that is functionally how it works. But even theoretically, to demand respect for something is not the same as to demand toleration. Not only is this not liberal, as the report observes, it's something else. Tolerance is only engaged when someone doesn't respect something. That's the point. If you like or approve of something, there is nothing to tolerate. You don't have to tolerate something you enjoy or like. And the fact that a belief has to be vetted by a judge for worthiness is deeply, deeply concerning. This allows an arm of the state to determine citizens' political opinions, the worthiness of them, not even consistently. There was one judgment they bring up which I think is just astounding. This is Thomas versus Surrey and Borders Partnership NHS Foundation Trust, which found that, quote, English nationalism is not worthy of respect in a democratic society because it includes anti-Islamic views. Could it be, by that standard then, that Islam is not worthy of respect in a democratic society because it includes anti-Jewish views?
Yeah, depends on the judge, though.
A judge that presumably has read the Quran, knows what's going to happen in the last day, and the animated rocks and trees that will cry out, there is a Jew behind me.
Depends how many judges are educated on said topic.
I mean, literally in the Quran, the last day, the apocalypse of Allah, isn't going to come until all the Jews have been exterminated.
That's the hadith that says what will happen.
Yes. And so it's specifically anti-Jewish, I think we can describe that as, reasonably so. And that's not... That would be surely not worthy of respect in a democratic society by that standard.
Although there is a funny thing in British law, if a text is older, I think it's older than 100 or 50 years or whatever the standard is, then it is exempt from all hate speech laws, which is quite funny. So that's why amazing. The Quran, the Bible, and so on and so forth are not officially banned, even though you could say that they hold anti-homophobic or so on and so forth.
It's very interesting. The report then proposes statutory protection for employees' freedom of expression. Very reasonable. It proposes a new test to establish whether the employee will have said something terribly damaging to a company's reputation. One, not concerned with the merits of the opinion, but the legality of the opinion. Is it a legal opinion? Should he be able to have it? If it is, it should be protected. Not exactly controversial. The thing must not show favour to particular beliefs. It must assume that any speech outside of the employment is not the concern of the employer, so there must be extremely extenuating circumstances to make it a confliction with the employer. So if you just have an opinion on the football or something, Your employer shouldn't have an opinion on that. The employer may reasonably restrict speech in particular ways, such as if you're working, I don't know, if you're working in some sort of particularly sectarian area, maybe you shouldn't be making sectarian statements online because that might inflame tensions and things like that. Fair enough. Or for certain religious, political, or social opinions in certain roles, which could include other subjects actually like football, because there might be a heavily politicised thing. But I can see why they are saying, well, look, they should have some defence in case an employee is defaming their company all day, every day. They can't reasonably be expected to not fire that employee, which I think is fair, But just for having statements that aren't connected to work shouldn't have any kind of political impact on your employment status, which I agree with. And any speech included in this, in what a person is free to say outside of these restrictions, should be fine. This would allow employers to discipline employees if they've actually done something, and it would allow employers to actually prove that it was necessary to discipline the employee. And that's the general meat of the In Protection of Free Speech report. Overall, I was genuinely surprised and impressed with the depth and complexity of the arguments. I do think there's a slightly more firm philosophical founding that they could have used rather than just relying on John Stuart Mill. I mean, I can point out a few of the issues with Mill's conception of rights because of his utilitarianism. But otherwise, I think it is very defensible. And I think that their proposals are not simply just free speech absolutist proposals. They are fair to both sides of the argument. And I think that the proposals in it would prevent almost all of the cases that we have had to defend. Harry Miller, Count Dankula, Posey Parker, any of these other ones. The suffragettes' ribbon that was called a noose, things like this. All of that would be protected as it should be. Any thoughts on this before we finish?
I'd love to see what the Conservative government does in response. Because if they're currently... I saw the other day Boris talking about, oh, don't worry, we're dealing with harms online by passing this. Then what the hell is wrong with them? Because that is not what they should be doing. It's not what's in the manifesto either.
Yeah.
They lay out that they must protect freedom of speech, and they should, is what they said in the manifesto. And that's why they should adopt something like this instead of adopting more censorious laws in the name of Labour.
Yes, exactly. Rather than following the Labour position, which is more online censorship, they should follow the Reclaim Party position, which is less online censorship. But yeah, so basically, big thank you to Lawrence Fox, Lucille Taylor, and Anna Lufty, as well as Francis Hoar for authoring this. Excellent piece of material. I imagine the Conservative government is going to ignore it, which is a real shame because it seems really necessary, timely, and seems to hit all of the right marks without being excessively belligerent against the complaints of the other side. So it seems to be a reasonable compromise that would actually protect people's rights and protect people's reputations as well.